for?
This is for... That one, Madam Chair.
All right, good evening. I'm going to call this regularly scheduled meeting of the Woburn Zoning Board of Appeals to order. I'd like to remind everyone in the audience that this hearing is being videotaped and audio taped, so please keep that in mind if you decide to approach the rail to address the board. To begin our hearing, I'd ask that people please join me in the pledge of allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The first item on the agenda is a continuation from previous months. This is the petition of Claire Contracting LLC, 41 Independence Drive, and Stephanie Ray, appealing the decision of the building commissioner to deny a building permit for a single-family dwelling at 41 Independence Drive, also referred to as Lot 48. Member Chatfield, a little brain dump there. Member Chatfield had to recuse herself on this matter as she is on the abutters list. So, Member Kavicki will be participating in this. Welcome, Mr. Tybee.
Okay, good evening, Madam Chair, members of the board. For the record, Joseph Tybee, Woburn and Redmond, 500 Unicorn Park Drive in Woburn. With me this evening is Attorney Ryan Douglas from my office, along with Tom Clear of Clear Construction, LLC. Before going with our presentation, I would just like to submit for the record a copy of a letter in support of the petition by a resident of 10 Bay Street, which is was one of the abutters, if I could submit this for the record.
Is that just, do you have one copy?
Yeah, I just received the copy, just one copy, yeah.
All right.
Okay, so this is an appeal of the determination by the building commissioner set forth in the application missing items form dated March 30th, 2026, that the lot does not have the required 100 feet of frontage on a street. I'm not aware of any current zoning relief being approved. Before I get into this any further, I'd just like to make a couple of comments. Number one, I have the utmost respect for Tom Quinn and seldom disagree with any of his positions on zoning issues. However, in this particular matter, I respectfully disagree with him. What I'd like to review before we get into the reasons on why we think this decision should be overturned, I'd like to just go over, for the record, what we've submitted in support of this appeal. So, with this appeal, we've submitted the following documents. Copy of application missing items form dated March 30th, 2026. 2, copy of the Foster Estate subdivision plan approved by the Planning Board on February 27th, 1961. 3, a proposed plot plan dated February 6th of 2026, showing the proposed single-family home. 4, the variance decision dated December 12, 1972, for Lot 28 Independence Drive, which frontage variance was also granted to lots 30 through 34 of Independence Drive. Number 5, a copy of the 2023 variance petition that was filed with the board, then withdrawn without prejudice, seeking a reduction in the frontage requirements. 6, the appeal of the building commissioner's determination filed on behalf of the applicant by the law firm of Marsh Moriarty, Ontel, and Boulder of Danvers, Mass., which appeal includes a written opinion dated March 12th, 2025, from Woburn Special Counsel Thomas Mullen, who was town counsel for the town of Linfield, to the applicant's prior counsel, Attorney Hall of Winchester, Massachusetts. Mark Salvati, the city of Woburn's current city solicitor, was conflicted because of his prior involvement in this property. We also submitted a copy of the opinion of former city solicitor Ellen Callahan Doucette, dated December 11, 2023, which opinion only addressed whether Lot 28 was protected on its own as a pre-existing non-conforming lot under Chapter 48, Section 6, and that's not something we're arguing this evening. For the benefit of those in the audience that are here on this matter, the matter before this board is an appeal of the determination made by the building commissioner. The hearing's not about the location of the house, it's not about drainage, it's not about blasting issues. It's a mutually respectful disagreement and opinions between the applicant and building commission on whether or not a building permit should be issued. It's our view that the 1972 variance was exercised and still valid for a number of reasons that I'll outline right now. And we did submit, as you know, a letter in support, which contains the number of items that I'm going to present to the board now.
Attorney Tarby, let me ask you, have you received a copy of a letter dated June 15th, 2026 in opposition?
Yes, we have.
Okay.
Thank you. So in terms of background, Lot 28 is shown on the Foster's Estate subdivision plan, which the planning board approved on February 27th of 1961. The lot contains 30,007 square feet and has 80 feet of frontage on Independence Drive. The applicant is proposing to build a single-family home. When the plan was approved in early 1961, the Woburn zoning ordinance had no lot area or frontage requirements in its residential districts. The city added those requirements on June 10, 1961, after this plan was approved. So they broke it down into two residential districts, A and B. Quite honestly, from reviewing the ordinance, you really can't tell which resident district it was in, but that's not relevant because one residential district required 15,000 square feet for lot size, 125 feet for frontage. The other requires 12,000 square feet and 100 feet for frontage. So several of the Foster Estates lots, including lot 28, were laid out with less than 100 feet of frontage. They became non-conforming only because of the change to the 61 ordinance. So in a decision filed with the city clerk on December 12, 1972, the Board of Appeals at that time granted frontage relief for 6 independent drive lots, Lot 28 and lots 30 through 34. The board granted the variance to Hillcrest Construction Corporation, which owned the lots. After the variance was issued, the 5 other lots, lots 30 through 34, were sold to different owners, and 4 of them received building permits. Lot 28 was kept by the owner and never built on. The 2 lots on either side of Lot 28, which were not part of the variance, had already been sold before 1972. I'd just like to point out in 2023, an earlier petition asked for a variance to reduce the frontage on this lot from 100 feet to 80 feet, so a single-family home could be built. But that petition was withdrawn without prejudice in January of 2024, before special counsel had reviewed the 1972. Withdrawal does not waive or decide the status. Then the applicant applied for a building permit on March 30th, that permit was denied for the reasons I've previously stated. The applicant timely filed an appeal within 30 days under General Laws, Chapter 48, Section 15. So it's our view that the 1972 variance was exercised and still applies. Under General Laws, Chapter 48, Section 10, a variance lapses if the rights it grants are not exercised within a statutory period of time. The law does not require that every variance allows be built. What matters is whether the holder acted in reliance on the variance enough to use the rights it gave. In our letter of support, we cited a couple of cases. One, the Hogan v. Hayes, which is an appeals court decision, and Cornell v. Board of Appeals of Dracut, which is an SJC decision in support of our position. We've also provided the board with a written opinion from the city's special counsel at the time, Thomas Mullen, on this exact question. Attorney Mullen reviewed the 1972 variance as special counsel and concluded there's been sufficient exercise of the Independence Drive variance to say that it remains effective with respect to lots 28. Mullen, in his opinion letter, gave two reasons. First, under Hogan v. Hayes, the original owner's choice to keep lot 28 after the variance issued was itself an act of reliance, because without the variance, the lot would have lost most of its value. And so the owner's best option might have been to sell it to a neighbor. Second, the 72 decision was a single variance covering 6 lots, and the owner made use of the variance by selling the other 5 lots. I'd just like to point out that, this board's not bound by Attorney Mullen's opinion, but we feel it carries weight to the issue at hand. The city hired Mullen to review the variance and the lapse question, and he found the variance to be effective. Again, the 2023 petition, as I just stated, in its withdrawal, does not defeat this appeal at all. And on behalf of the applicant, for the reasons we've stated, we respectfully request the board to reverse the commissioner's March 2026 determination to the extent it says lot 28 lacks required frontage and lacks zoning relief, and to find that 1, lot 28 was part of the 1972 frontage variance this board granted. The 1972 variance was used and still applies to lot 28. And thirdly, the building permit should not be denied for lack of frontage or zoning relief as long as lot 28 meets all other applicable requirements under the zoning ordinance and the building code. So with that would concludes our presentation.
Thank you. Your Exhibit H includes the notice of variance that was recorded, but I don't believe we actually have the variance that was granted. We don't have the variance itself. So you're telling us that the frontage was the subject of the relief, but I don't have the variance. I only have the notice of recording of it.
How it was issued.
So literally this piece of paper says nothing about frontage.
The record, and I believe that's what Attorney Moriarty did.
Is there in any of these materials, is the application for the variance included?
Talk about 1972?
Yeah.
No. But this file was looked at by the previous city solicitor and also special town council for the city of Woburn.
So you're saying there's no actual decision for this variance?
Back at this time in the 70s and into the early 80s, you would have a one-page decision, okay, just like this, and then there's usually a reference to the, sometimes there's a reference to a book and volume number in the city clerk's office, but this was with a variance. So I don't see any reference to a volume or page number on this particular document.
So it's, and I wanted to thank you for the material that you had submitted. It was very helpful in preparing for this hearing. I have some questions about the case that you rely on, the Hogan v. Hayes case, because the facts of that case are very different than are before us. That case surprisingly relies on equitable arguments to uphold the variance. And in that case, the lot was created by the variance. So there was one piece of property that was subdivided into two separate lots, and the only reason they could do that was because they got a variance. These lots already existed. And so the lot had already come into creation. A variance was not needed to create the lot. And in the Hogan case, the trial court and the appeals court said, gee, it's not really fair that, you know, this woman subdivided her property and she kept, you know, two non-conforming lots, one of which had a house on it and the other which didn't. And she sold the lot with the house on it to somebody, and then she sold the empty lot to somebody else. And then when the person who bought the empty lot went to build their house, the person who had the lot on the other house complained and said, no, you can't do that. And the court, that was really important in the court's decision. We don't have any of those facts here.
I'm gonna have Attorney Douglas address these cases.
Okay, thank you.
Okay, so, Ryan.
Thank you. And just for the record, Attorney Ryan Douglas with Reuben Rodman. So the Hogan case, you know, yes, the facts are a little bit different, but she got the variance to divide the lots. I think it was in 1974, which is when she requested the variance, and then she sold off the other lot in 1975. And yes, the division of the properties was a result of that variance, but at the same time, the variance covered both lots. And I think that that's the important thing to note here, is that the variance for that case covered both lots. And because there was a retention on her end, 8 years later, when there was an attempt to build on the retained lot, the neighbors then said, well, wait a minute, no, you can't build on that lot. You know, there's been a lapse of time, a number of years has gone by, and the court, the appeals court said, well, actually, no. The fact that she retained the lot, and there was a building that was done on the other lot that she did not retain, is enough to state that the variance was executed. She recorded the variance. Then after it was recorded, there was an actual substantial step that was taken onto one of the two properties where at least some construction was done within the year. And then, because she retained the property with the intent of at some point later on either selling it with the value of the fact that there's a variance on the lot, or building on it herself, that's enough. And what the purpose of providing it here is to say, look, you know, the variance that's at issue was granted and covered lot 28 along with 30 through 34. So here, as long as the variance was executed as to lots 30 or 30 through 34, any one of them, that was enough to trigger the execution of the variance to make it valid. And then you can, and just to note, unless it's actually, there's something in the four corners of the document itself or in the conditions of the variance that provides, look, you can't actually go and use this variance past a certain date, it runs with the land. So once a variance has been executed, it runs in perpetuity. There's cases, I think that the case that you mentioned, the Hogan case, is a great example of that, where you can go back and still exercise, or not exercise, but rather rely on a variance that had been exercised 8 years before.
Yeah, so the exercise that the court relied on was her sale of the lot with the building on it.
Yeah.
She sold that in 1975.
Correct.
The variance was granted in April of 1974, so she exercised within a year because she sold a lot. What year were the lots in this subdevelopment sold?
Well, here, the execution occurred within a year of getting the variance, I believe. You had at least the sale of some of the lots, and the sale of some of the lots was in anticipation of them being buildable lots.
Sure. My question, though, is when were they sold? Were they sold within a year?
I believe so we provided the deeds as one of the exhibits. I think Attorney Tarvey has some of those deeds, but I believe that they were sold, at least one of the lots was sold within the year.
Attorney-
Yes, it was between 1973 and 1976 where the lots were conveyed. And so just so you know, that's exhibits D and E in our submittal.
D is the notice of variance, and E is the 2023 application for variance. I'm looking at the June 11th, 2026 package.
So if you look at the they don't have these. So there were a number of deeds, and I apologize that those didn't make it into the record, that of the conveyances that came out from that. But those were done in March 22nd, 1974. You have another February 27th, 1973. So that's right after the variance. You have one in November 21st, 1975. So there were conveyances that were made within the 1 year of the variance being granted.
Right, and do you have those that you're going to submit?
We do. We'll submit these into the record.
And since there apparently is no decision other than this one-page form, if the, thank you, if the zoning board imposed conditions, they would be reflected on the form, right?
If there were any conditions that were imposed, then yes, they would be reflected on that form.
Do you have any idea what the hardship was that the zoning board relied on in 1973?
You know,
That was 1972, as you know.
Sorry, December 72?
Well, I mean, there was a different hardship standard back in those days.
so I'm not aware of what the hardship was. However, there was a variance that was granted, and there was no appeal, as far as we know. The variance was exercised, and the homes that exist today exist today because of that variance decision, at least for lots 30 through 34.
All right, and so it's your position that recording the variance and selling the other lots in the 1970s was sufficient to protect the variance on Lot 28?
Yes, and you'll find that the Cornell decision also supports that theory, even though in that case it was a decision where the court said, look, there wasn't a proper execution of the variance. The court then goes into a long description of all of the things that would have satisfied the execution of the variance, and that included selling off other properties, withholding some to potentially build on later. So I think that the Cornell decision helps us there.
Yeah, but again, this is, all of these cases are one piece of property being divided into two lots. And that's not what we have here.
So what you have here is it's still a situation where you have multiple lots that are covered by the same variance. So I see them as very analogous. It's just whether you split them before or after. And here it's a variance that already covered lot 28.
Yeah, but
So the-
nothing was done.
But it's one variance that covered all the lots. It was a variance that was being issued collectively for all of the lots.
Oh,
And-
I completely disagree with that. There's 5 or 6 different variances that were recorded. There's a variance for each separate lot. There's not one variance that says, here are all the lots that we're giving relief to.
So the decision of variance, I believe, covers lot 28 and then 30 through 34.
But I've asked for the decision, because I don't have a decision that says anything about, and I'm told there isn't one.
So
But
that
there are
is
5 or 6, right? How many lots are we talking about?
5 altogether, 6 together, I
I
believe.
think it's 6, right? There are 6 separate notices of variance recorded in the Registry of Deed. Each one refers to a single lot.
Correct.
So I don't really think it's accurate to say that when, there's one decision, this one decision protects all of the lots. It's a community of lots, so you have to look at them as a community. I don't think that's true, and I'm really having a hard time when all of those other cases are a variance that subdivided one lot to create 2 adjoining lots. And again, that's what happened with all the lots on the other side, lots 34 through whatever they were. Lot 28 is over by itself. It's not contiguous to that other property.
I think it's important that the board not lose sight of the fact that Attorney Hall raised this issue with the city solicitor a couple of years ago, a year ago. City solicitor, because he was conflicted. City retained outside counsel, Tom Mullen of Town Council in Linfield. He's also been Town Council of Wakefield. He's been a Town Council for as far back as I can remember, at least 20, 25 years. Although you're not bound by his opinion supports our position.
I know, I understand that. But there are also other cases that go against your position. There are other cases that say you have
Like
to
that
do...
with any legal issue.
Well, absolutely. That's why I need to look at them all. And there are cases that say, yeah, really, it's not just enough to record something and then, sit around for 50 years.
Just out of curiosity, were any of those other cases put into the record?
What do you mean?
Those cases that you're referring, you said cases that go the opposite way.
Oh, so I did research. So I'm looking at Grady versus Langone, which is a land court decision from 2011. I'm looking at Daniel v. Harrington, another land court decision from 2014. And even the Cornell decision that you rely on, again, it only addresses one lot that was subdivided into 2 adjoining lots. And it says, you have to do more. Hold on a sec, let me find it.
So I agree that you have to, Cornell, in the Cornell case, the court found against the individual trying to execute the variance because they found that the variance lapsed. It's just that the Cornell decision explains what does need to occur for a variance to be executed. And selling off one of those lots, even if that's part of the issuance of the variance, that's still enough because you're relying on the variance to sell the property and have it be developable.
Right, but it's one of 2 lots, not one of 6 lots, where the lot that's at issue now doesn't touch any of the other lots. And it's been 50 years. It hasn't been a couple of years, a few years. It's been 50 years.
Well, respectfully, even if it's been 50 years, I don't think that that's a relevant analysis because once a variance is granted, it runs in forever.
Only if it's exercised.
Exactly.
Right. And so that's the whole issue. Has the variance for Lot 28 been exercised?
Which we believe that it has because of the developments that have taken place and the sale of the other parcels. Development and of the other parcels and the sale of the other parcels. That's our position.
No, I understand. Yeah, I'm just struggling with whether the case law is analogous. But I'll, let me see. Are you relying, there was an alternative argument in the June 11th submittal. Are you relying on that as well?
So we'll let the submittal speak for itself. I think that when you have an argument that's not as good as your primary argument, you can let it rest on the record. But we do think that this argument is sound, that the variance that was granted was executed. You can look to the other lots to demonstrate that. And the fact that this lot was not built on and was retained to be built on at a later date goes very much the way that Hogan goes, very much the way that the dicta in Cornell goes.
Any other members of the board have any questions? Let me ask, is there anyone in the audience who cares to be heard in connection with this appeal of the zoning enforcement officer's decision regarding 41 Independence Drive, also referred to as Lot 28? Sure, if you could come to the rail, if you could just identify yourself for the record, name and address, and please speak into the microphone.
Yes, my name is Jonathan Britt from 33 Independence Drive. It's the fourth house from Lot 28. We support the building commissioner's denial of a building permit to develop Lot 28. Mr. Tarby did a magnificent job in summarizing the history and that the variance should still be in effect. But in his summary, he asked the board to recognize the relief that was granted more than 50 years ago. 50 years. I asked that the board consider at what point should the project be considered abandoned. 45 years has lapsed in activity. Seems reasonable to consider that the project has been abandoned. 45 years meaning from 1978, where the Zoning Act took effect, to the 2023 application. So I ask that the board uphold the commissioner's determination denying the building permit. Thank you for your consideration.
Thank you very much. Is there anyone else who cares to be heard? Sure, if you could approach. Please identify yourself with name and address.
Hi, my name is Daniela Ojeda. I live in 43 Independence Drive. We moved there 5 years ago, and we love the neighborhood. I'm all about the community, and we'll be happy to have new neighbors at any time. But I do have a big concern on the ledge that is in the property. And we were here 2 years ago when the previous time they tried to get a permit. And I just have so many questions. Like they said, like if this was not built 50 years ago or during the past 50 years, what is different now that is going to make that lot buildable, right? Like on top of the variance and on top of all the other regulations, if this permit is approved, I would like to have a little bit of information on what are they going to do with respect of the ledge, how they're going to process, to build, to get into the ledge, hammering, or I don't know if blasting is needed or whatever other method they're going to use, and the impact that can have in the two houses. My house and our neighbor are really connected with that rock. So I'm concerned of any potential structural damage.
Sure, understood.
And then also, if they are approved, I wonder if it's necessary that they do pre-existing survey, like to understand the existing conditions, and then if some damage happens, like how.
You mean examine your foundation and film it so that if there's a crack after any, yeah, okay.
Yes.
Let me, sorry, I didn't want to cut you off.
Yeah, so that's one, and then so we have talked to them. They came to the neighborhood and explained what they're gonna do, and I saw the drawings. So it looks, it shows the driveway, the ledge is like the rock right there is super high, so there's gonna be a lot of work to do that. But there is also more potential work that they need to do, like utilities. They will have to like dig even deeper to do that. So I think the activity will be even more than is just presented for now. So I was just wondering if there is
Sure.
any.
And did you have the opportunity to ask those questions of the applicant when they showed you the plans?
Yeah,
or-
they show the plan, say, yep, like they are gonna hammer and it's gonna vibrate. It's construction, so construction will have noise, will have vibration. But I was just wondering, how is that held, accountable?
Sure.
If they have insurance, or all this other stuff.
All right, well, let me ask Attorney Tarby to respond to those questions. I don't know if you can give your neighbor any substantive information about if the relief is granted, how her foundation and
So,
will be protected?
So, just respectfully, that's not an issue that's before this board tonight. It's not relevant for this conversation.
I completely disagree. You're asking for relief to build a house, and I think it's entirely appropriate for the applicant to respond to a neighbor's concerns about ledge. Sure. So are you prepared to and is he here? Oh, sure. Well, then let's answer the question.
Doing?
Hi.
Yeah, just to address that, so last Wednesday we did have a neighborhood meeting, and most of the concerns were about the blasting, which we kind of explained we hope not to do. There is ledge, as you can see from the topography of the lot. It raises at the beginning and then flattens out, and then kind of falls off towards the back. And that's why we place the house towards the back. It's kind of a deeper house, and we place the garage on the left side where there's rock and we wouldn't have to dig there. And then as the lot slopes towards the back is, where the main body of the house sits. So we obviously hope not to blast because we know the impacts of it. So that's kind of where we set it back. And then obviously if the house plan, the front of the house is kind of a storage area. So if that needed to be a crawl space because of the rock. We tried, basically choosing the house and the location was, an attempt to make it the lowest impact possible. And obviously there is plenty of room to shift the house around, so obviously we don't know exactly where the worst rock is. So, but if the case came up, we could shift the house around within the setback.
And are there any municipal or state regulations on, if you have to blast, does the city of Woburn and/or the state regulate that?
It is regulated. I don't have, regulations.
Regulated through the private.
Thank you. Oh, yeah, I should know that.
Yeah,
Gone over this before. Thank you,
Few
Mr.
times.
Tarby. Yeah. Usually with much bigger projects.
much bigger projects, yeah.
Do you have any more questions?
So I understand the position of the house, and to us, it's a beautiful house. I look at the drawings and it's going to be great. And the house is not my concern. It's more how are they going to get to the house? That's where it's a wall of rock. And how are they going to get the utilities to the street? So the work in the ledge is in the front. So the whole 78 feet, 80 feet, whatever they have the frontage, it's 100% ledge. So
And is that, do you know that yes, this like, big bump at the curb. Do you know that that's actually ledge, or is it, a berm? Is it a soil berm? I have no idea.
Well, we believe that there is some ledge in there. I mean, one of the first things we would like to do is scratch everything, all of the dirt out of there and see kind of what we're working with. And we hope to kind of hammer our way, make a driveway up. We're not trying to blast the whole lot to pieces. We want to keep it low impact, but yeah, we don't know exactly what's what, but like I said, if it was the case where the right side were more accessible with the ledge, then maybe we'd shift the driveway to the right. So obviously, it doesn't help us by blasting at all. So we would try to keep it to a minimum, and ideally no blasting at all.
All right. Thank you. So I think the reality is it's really too soon to tell without doing any testing of what looks like a berm at the front. But I'm sure that if you reach out to the building commissioner or the fire department about any concerns, that they would address it. And I'm sure if the board grants the relief, that the applicant would work closely with its neighbor to address all reasonable concerns.
Noise mitigation, vibration,
The
monitor.
noise that they can work between 7 and, it's still 7 or 6. It's a little different in the summer, but they can start working at 7, and that's the reality of what's allowed in the city.
Okay,
Okay.
thank you.
Thank you for your time. Is there anyone else in the audience who cares to be heard in connection with this appeal?
Board, Mark Lynch, 39 Independence Drive. I'm a direct abutter on the right. My understanding when doing a little research is that, once a variance has been granted, it needs to be exercised within a year. There could be extensions if you're doing drawings or excavating, whatnot, but it was issued in 72, and I think the laws changed in 78. The frontage was going to be set from 80 to 100. And here we are 54 years later. And I don't know if you guys have seen that lot, but I sent some pictures in to Gordon Vincent depicting, different locations of the ledge from my backyard, from the front yard, and I have serious concerns. And I respectfully wish you guys could uphold Tom Quinn's decision on this. It's gonna do some severe damage, whether it's, cracking it, hole ramming it. My house is all plaster, so it's gonna take a beating, and I've been there since 2002. Never had water in my basement, and I really don't wanna have any surprises. Thank you.
Thank you for your time. Anyone else in the audience who cares to be heard in connection with this appeal of the building commissioner's decision? Mr. Tarby, you want to come back up?
You've raised a couple of cases, and we've presented some cases. Would you like us to brief the legal issues and submit to the board?
Well, so so my concern is, so even the Cornell decision, the court used this language of, at the very least, right? So we have an instance that the court said, even if the variance had been recorded timely, we would nonetheless conclude that Cornell's actions fell short of exercising the variance. We agree with the land court judge and the appeals court that at the very least, in addition to recording the variance, Cornell needed to obtain a building permit or convey one of the lots in reliance of the variance. And that's at the very least. And there are other cases. The other cases I was really surprised that the land court ruled against the petitioner. I mean, there was one case where the gentleman who received the variance had to go to the planning board. He had to get septic permits. He was doing all that, and the land court said, yeah, no, that's not enough. So it seems like there's a disparity. And again, I'm kind of stuck on the fact that the cases, that the Hayes case is a little simple subdivision of 2 lots. And it would make sense, right, that if you only have 2 lots that were created by a variance, we don't have that here either, and we have this completely separate lot, Lot 28, it's not adjoining the other 5 lots. There was an individual variance granted for that. So it didn't come into existence for the variance, so the existence of the lot doesn't depend on the variance. I think that's really different. And you've put a great deal of effort into the submission, and I've read everything, and I read the other lawyer's analysis, but no one actually, so that Hayes case, it's from 1985. And so I always like to find more recent cases, and so that's why I went looking, and I'm like, oh, gee, here's some more land court decisions. So really, I'm struggling. But again, I'm only one person. So there are 5 people who are going to vote on this, and maybe it's appropriate to see if any of the other members of the board, have any feedback.
But, again, based on the cases you've raised, the ones we've raised, we're willing to put the effort into putting together a more detailed brief to address your concerns.
Well, let me ask, because I don't, does anybody else
Yeah,
have any concerns?
Sorry, I think when I was studying this, I thought this flowed just like Hogan versus Hayes. The variance was recorded, right? And those other lots as well were divided up at the same time via variance, and they were acted upon. They were executed, conveyed, something else happened. And then I think with Cornell versus Board of Appeals of Drakeit, right? I think the problem with that one is that they did not record the variance in a timely manner. Is that was the case with?
Yeah, even if the variance had been recorded timely, and in that case, the actions fell short.
Right. So, but I'm just seeing in these 2 court cases is it seems like the courts are saying, hey, you got to do something with the registry of deeds. You got to file it. You got to execute it that way. Then you got to convey the other lot in some sense. Yes, I know these are only one giant lot compared to 2 in 2 other cases, but it seems to be like 2 actions that they're asking for when it comes to these old variances. I didn't see anything about time. I think it was 8 years in the Hogan versus Hayes from 1974, 9 years till building permit was issued in 1983, and that's when the
Correct.
court cases started with that. I don't think the courts in Massachusetts are talking about how much time went by, whether it's 8 years or 50 years or 60 years. I think they're just looking for, was it recorded at the Register of Deeds, and was there some other action involved with the variance? And that's kind of how I see it at the moment. But yeah, I'd love to, if you wanted to brief these other cases, and I can look them over as well. I think it's only beneficial.
Any other comments or feedback?
Yeah, I would also appreciate that, a brief.
All right, actually, I had some other factual questions too, actually, you might have answered them when you submitted the deeds, and I'll provide this to the clerk to include in the record. Were any lots other than Lot 28 remain undeveloped?
I don't believe so, but we can double check and supplement the record. I believe 30 through 34 are developed. And 28 is not.
So how do you wish to proceed?
Well, would like the opportunity to brief the cases that we've discussed tonight and provide further information to the board.
Sure. Let me just tell you, so I'm looking at Daniel versus Harrington. It's a land court decision from 2014. And Grady versus Langone, Langone. It's another land court decision from 2011. And I hadn't,
Forgive me, what was the first case? I was just writing it down.
Daniel versus Harrington, Grady versus Langone. And I hadn't finished, I don't think, well, I ran out of time shepherdizing Cornell. In connection with the alternative argument, I had a question on that because the city solicitor Callahan's opinion referred to the planning board approval, referencing that it was conditional, which she said she was not.
Talking about Alan Callahan, who said?
Yes. Let me see if I can find it. Where it is. Oh, here it is. It's in her footnote. The subdivision plan that was signed on February 27th, 1961 contains the note, "This is a conditional approval." Well, I, of course, want to know what were the conditions that were put on the approval. So, and again, that's only if you intend to rely on that alternate argument. So then are you requesting a further continuance to submit additional
Right.
briefing?
Yes.
May I ask one question? So is it Attorney Thomas Mullen, is he representing would he be representing the city or representing this board if we needed his counsel? Is that,
So, my understanding is Attorney Hall requested an opinion from City Solicitor Salvati. Since he was involved in the matter,
no,
he went to outside counsel.
yeah,
Yeah, but, as I indicated,
Okay.
Mr. Mullen, provided his opinion, but as we indicated, you're not bound by that.
sure, yeah, I understand that, yeah. I was just wondering if we voted in favor of you and someone in the public wanted to take this to land court, I was wondering who may defend the city, I guess, in that sense.
City would have to have outside counsel.
Outside counsel, yeah, okay. And again, it's not that, we're not the end-all for everything, right? You could appeal it, the members of the public
Yes.
could appeal it. All right, thank you.
I just had a couple of questions. Do you know, just offhand, without, the map's a little difficult to read, how many lots in this development are without sufficient frontage that are built upon?
There are a number of them. We do, just
Right, are the two adjoining lots?
One is, and the other's not.
Okay.
So one has like 74, 75, and the other has just about 100, because is it?
there are, several lots that don't meet the 100 feet. There are several lots that don't meet the 100 feet.
because it just seems, what we've heard, neighbors, is some valid concerns about potential blasting, so I mean, in the continuance, maybe that's something you could address a little more in depth, the likelihood of that having to be done if this were to be approved, and what, mitigating steps would be taken.
We'll look at it.
I remembered my other question. So the application, so the petitioner is Claire Contracting LLC. Stephanie Ray is identified as the property owner. Is there an existing contract in place between Claire Contracting LLC and the property owner? All right, and the reason I ask is because when I looked up the deed, this property is held in trust, so it doesn't appear that Ms. Ray owns it personally, but she owns it in a representative capacity, so I had wanted to, yeah. So there's a fiduciary deed into her as trustee of the Vincent Tamburino Trust. But if she's not the petitioner, then I guess it's irrelevant for my purposes. Okay, thank you. That was the, I think the only other thing I had. How does the board wish to proceed on the petition or the appellant's request for an additional continuance?
Make a motion to continue to the July meeting.
Madam Chair, there may be an issue with attendance in July.
Why am I not surprised? What would our date typically be?
It would typically be the 15th.
Yeah, I'm not going to be here.
That's two. If it's going to be moved to August, I would respectfully request August 12th because of the election schedule for the city clerk's office, if that's doable for everybody.
Chair, I'm not available on August 12th.
It is the season.
Then we would have to do August 19th. Does that work?
In July, that work.
There is not.
Well, we're not going to have enough bodies
There's going to be two members that are not going to be here.
on the 15th, and then I'm also not available on the, well, hold on. Let's see if we can find a date in July.
Oh, that, you also may have an issue with the building commissioner.
Okay.
On August 5th.
August 5th, I'm not available.
Does it have to be a Wednesday?
No, we have occasionally, found special days for just this reason.
Madam Chair, we've met downstairs in the engineer's office on odd days.
Right.
Would there be a day during the week of July 13th that could work for everyone, or you away that whole week, or?
I'm traveling the 13th through the 15th. I'm available on the 16th.
Available the 16th, July.
It's just brutal with, vacation schedules. What about the week of July 20th?
That works for me. I'm not sure if it works for Gordon.
Oh, no, I'm going, I don't have vacation until 2027, Joe.
July,
The week
What?
of July 20th?
Wednesday, July 22nd, I will be not in town. I'll be gone for that Wednesday.
We'll be here or
I will
not?
be gone, so I couldn't make the Wednesday.
All right, what about any other days that week? I'm totally open that week.
Should be able to.
City council has the room on the 21st.
Okay, so what about the 23rd?
I mean, we could meet in the committee room on the 21st too. I mean, that's not,
Yeah. Does either the 21st or the 23rd work for everybody? 21st? Does the 21st work for you?
Well, I have a couple of matters before the council that night.
We'll give you a dispensation, or we'll work it out somehow. You're going to be first on the list in this one.
All right, that sounds good.
All right.
They start at 7 in the summer?
Start at 7, yeah.
Oh, okay.
Well, they're starting at 6
Oh,
now.
that's right,
Summer
summer
hours.
schedule.
But they have
Yeah.
a long agenda, you know, Cummings is on that night, so they can put them on first.
All right, so July 21st work?
6 o'clock?
Yes.
In the engineering room, is that right?
We could either do the engineering room or we could do the committee
Or
room.
the committee room? Oh, yeah, okay.
I'll see whatever's, I'll ask whatever's
Can't
available.
bump the city council out, can
We
we?
cannot bump the
No.
city council. No. It's a city council chamber after
Nor
all.
would we want to. All right. Did we have a motion, or we got all caught up in the,
We did not have a motion.
Okay.
We
The
just-
motion to continue to the July 21st meeting at 6 PM in the conference room right over there.
all in favor of the pending motion?
Aye.
All right, so this matter is continued
Thank you.
July 21st. Thank you.
Have some literature for this one, too.
Yeah.
Okay, thank you. That can go in the folder. This is supplemental plans for
Oh, thank you. Oh, thanks. I think I have two. Aren't these the same? The second item on our agenda is another continuation from previous months. This is the application of Greystone Investments LLC, 31 Grape Street, seeking to reconstruct a single-family home at 31 Grape Street. Welcome back.
Okay, good evening. For the record, Joseph Tabby, Woburn, Redmond, 500 Unicorn Park Drive, Woburn. Here on behalf of the petitioner. Just to refresh your memory, petitioner is seeking a special permit to demo the existing non-conforming house, build a new one. I believe we fully vetted this at the last meeting. And at the conclusion of that hearing, the board had requested revised floor and elevation plans and a site plan that would show the proposed bulkhead. And then on the site plan, the engineer had shown the distance to the easement. So that was removed, and we listed all of the setbacks on the left, right side of the house. So it's very clear on where all the setbacks are. So on the revised site plan, you can see the bulkhead to the right rear of the property. And on the zoning chart, you can see the four side yards on the setbacks on the left and four on the right. And then on the floor plans, sheet S101 and sheet S102 show the bulkhead. Now, the elevation plans were last updated on May 26th, 2026, and the site plan, plot plan was updated as of June 8th, 2026. Those would both be the plans of record.
So I counted wrong last time because I thought we had 7 different side setback measurements, but we have 8.
Yeah,
I think that's a new record.
4 on each side.
Hold on, I just want to see the, is the bulkhead shown on any of the, floor plans? Oh, yeah, I see it. Got it.
S1,
A104.
S101 and S102.
Okay. All right, do any members of the board have any questions for Attorney Tarby?
Not, I think that we received what we asked for.
Let me ask, is there anyone in the audience who cares to be heard in connection with this request for a special permit to raise the existing single-family home at 31 Grape Street and construct a new single-family home?
Are they also adding a second floor to the garage? Are they adding a second floor to the garage?
With Oliver, with a gray stone, and yes, we are adding on. We are building over the garage as well.
And do we have a plan for the garage?
Yeah, it should be all in the building plans.
Pardon? Do you know what page?
Yes.
It's going to be a master bedroom up there, correct?
Correct. Yes.
A104 shows that.
Oh, so the garage is attached?
Yeah, it's going to be attached.
Yeah. The master bedroom is going to be over the garage.
Okay.
Okay, got it.
Did you have another question?
I did. Attorney Tarby, forgive me if I asked this last month, but is this going to be a two-family or is this staying as a single family? This is going to be a single family? And our decision, if we put a condition on that with our usual jargon saying that, this condition was put on in the belief that this is going to stay a single-family home, you'll have no problems with that? Okay. Just looks like the way it spreads out, if you will. Appreciate that.
Any other questions or discussion? Excuse me. How does the board wish to proceed?
I'll make a motion to approve the special permit based on the updated drawings, documents submitted this evening, and on the condition that this special permit, that the house will stay as a single family. Our usual.
Second.
All in favor of the pending motion? Aye. All right, so that passed. You're welcome.
Madam Chair, minute recess?
Sure. I'd ask for a motion to adjourn for a quick recess.
So moved.
Second.
All in favor? All right, we're adjourned. Yes. To end our brief recess and return to the agenda?
So moved.
Second.
All right, okay. The next item on our agenda is the petition of Jeffrey Simpson, 1 Carroll Road, seeking variances in connection with the reduction of a front yard setback to build a pool and a fence higher than 3 feet within the setback. Is the applicant here? Okay, if you could approach. Hi.
Hi. So I'm here for a request for variance for a setback. There's an existing pool with a structural defect that I'm looking to replace. There's an existing fence. There's no change to the setback. There's no new encroachment. Having a regularly shaped lot with 2 sides of frontage, approximately 50% of my perimeter is affected by setback, the frontage setback. So I just want to replace the pool, replace the portion of the fence that's made out of cement and starting to crumble with the rebar starting to show through.
So your petition doesn't really address the fence. So what's the relief that you seek regarding the fence?
Replace the existing section of fence with a new vinyl fence so that I can extract the pool out. That's not a game changer. If I have to forego the replacement of the fence, that's fine. We have the equipment there to do it at that time. It's an existing fence that if you look at the photos provided, show that there was a fence on top of that retaining wall back in 1964. That's been replaced with a cement fence. That cement fence now is non-repairable because it's custom-made concrete, from what I'm told.
That's what it looks like.
It is. It's definitely so. I'd like to just replace that with something a little bit better, vinyl-looking, same location.
All right, so your petition says replace existing pool and fence legally pre-existing and non-conforming to front setback. New pool / fence not intruding to setbacks any more than the existing pool / fence. And I don't know. So you have a variance petition, but it says it's pre-existing pool and non-conforming fence. And in order for the board to treat this as a special permit as opposed to a variance, the board would need to find that the pool and the fence have been in their current locations for at least 10 years.
So I've provided aerial photos of the house from the city department, where Woburn started flying over in 1999, I believe. There's visual photos of 2006 before I bought the house in 2012. There's trying to think of what else there was. There's anecdotal evidence of the fence from the photograph provided from May of 1964, which shows the fence and the pool house that's next to the pool.
So we have these various images, and one has a handwritten notation on it that says 2006.
I wrote that in there just because there are so many different photos.
Where did you get this?
The city engineer's office.
All right, you
Actually,
printed
Mr.
this?
Simpson got this from the city engineer's office.
Okay.
But it was provided directly to Mr. Gordon
Right.
from the city engineer.
Yes.
Yeah. Can you confirm that this photo was actually taken in 2006?
I cannot confirm it. I confirm that's what the information that I got from the city engineer's office is.
Okay. Did the city engineer say, oh, this is a photo from
No, the
20?
GIS coordinator said that. It has indicated that's a photo from 2006.
Okay, thank you.
Madam Chair, I was just going to say, if you Google map it and you go to Street View, you can click on, you toggle down to 2006, and you can actually see the fence and the water there as well. So
Sure,
I,
if
I
were-
would say there's plenty of evidence here to say that this should be not a variance, but just a special permit.
Sure. Well, even just that from 2006 is sufficient, because I have the same question about, like, this says 1990s black and white aerial imagery, but it also says 2001 aerial imagery, so I'm kind of like, well, which is it? So I'm not going to rely on that. Okay, we have the picture of a stockade fence from 1964. And I think you had also submitted letters, correct?
Yes.
Right. I think there was actually one of the letters was,
The letters are from all the
Particularly-
direct abutters that are adjacent to my property.
yeah,
Letter from Laurie in her 70s stated she swam in the pool in the
yeah, that's actually the one that I thought was,
pool in the when she was a teenager.
yeah.
Best I could do.
Okay. So I think you have established that these are both pre-existing. Oh, wait a minute. I had to look at this. All right, but it's not a building, it's pre-existing non-conforming structures, right? Because the pool is not a building, but it is a structure. Let me just... Okay. All right, so I have questions about the size of the pool, because I can't tell from looking at this that the new pool that you're proposing is or is not the same area as the pre-existing pool.
It will have a different shape. It will fit within the existing setback and will be smaller than the existing pool.
Sure, but I can't, it's the part, your representation that it's smaller that I can't tell just from looking at this, because there aren't any measurements.
Sorry, ma'am, just if you could confirm, did the surveyor overlay the new pool?
That is
I see a
correct.
shadow behind it, I'm assuming that's the existing.
The rectangular structure is the
Right, it's
existing
like a
pool,
trapezoid almost.
and the rounded structure is the new pool proposal outline, and that design was provided from the pool company to the surveyor to overlay on the plot plan.
See the shadow of the existing.
Oh, yeah, I can see that, but my point is, I don't know what the square footage is of the existing pool. And I assume, because this says proposed pool 18 by 33, which I don't really know how you get to that when it's got all of those shapes. But, so that's my question, is what's the square footage of the existing pool and in comparison to this
That's what the
proposed
pool
pool of
company gave in the,
1833?
that's what the pool company provided in the CAD file to the city, to the surveyor to overlay.
I understand that, but I don't know what the area is. And I tried even, I colored in where the proposed pool goes outside the boundaries of the original pool, and I put slash marks as to where the proposed pool is inside the boundary.
We're not set on the pool size. I'll make the pool smaller. You could put a condition in there that says that the pool can't go outside the existing boundaries.
I just want to know
That's
the
fine.
area.
I don't have the CAD file. I don't have that. Not readily with me.
All right. And then the other question I have is about the fence and the retaining wall. So I assume, but I can't really assume because this is a retaining wall that I need to know is completely on your property and is not in the city's right-of-way. Because the plot plan doesn't show the retaining wall at all. So I have a concern, like, so I'll just be like really frank. I'm not going to vote for anything that would allow the retaining wall to stay on city property if it's on city property and then have you fence it in. And if that retaining wall was built in the 60s or even before, you know, it's not uncommon that things that were done a long time ago weren't necessarily built based on a plot plan or a survey. So, and there's nothing on the plan about the retaining wall or the fence. The other issue, the building commissioner views when you put a fence right on top of a retaining wall, if it's all in one plane, the building, so if you have like a 2-foot retaining wall and then you put the fence, a 6-foot fence right on top, the building commissioner sees that as an 8-foot fence. And this picture, so currently the building commissioner requires a, like an offset, a fence to be offset.
How much?
You'd have to speak with him about it, but all I know is that if the fence is on top, directly on top in an unbroken plane, you know, it wouldn't be a 6-foot fence. It would be, he'd consider it a 6-foot fence plus the 2 feet.
I understand.
All right, so that's all of my questions and comments. Any other members of the board have any questions or comments?
A couple. First off, should we make a motion to treat this as a special permit?
Yeah, I think that's appropriate.
Should I make that motion, or I think petitioner would want us to change this from a variance to a special permit. It's less of a legal standard. For the variance, we need to know a lot of the characteristics of what's going on, shape, topography of the lot, soil conditions to grant you something like that. If it's a special permit, we could just say, is this more detrimental or not to the neighborhood?
Yeah, no, we had some discussions on whether it should be a special permit or a variance. I've been dealing with this for 6 to 8 months to try and make sure I submitted the right paperwork. This is what I was told to submit, so this is what I submitted.
Yeah, no, it happens all the time.
So, that's fine, yeah, I'd be
okay.
fine with that.
And so I'll make a motion that will change this to a special permit.
Second.
All in favor of the pending motion?
Aye.
Okay,
Okay,
so,
in this massive paper, I left that file in my file cabinet again, so if you give me 30 seconds, I will.
okay. Much paper? Well, we have a form that when we change the request for relief from variance to special permit. So we'll need you to bless that. Let me ask, is there anyone in the audience who
I
cares?
just had a couple of other questions too.
Okay.
Now, since this is a special permit, I'm not too concerned about the size of this pool here. We've got 3 dimensions coming in from the setbacks here showing that. 18 by 33. It is what it is. Maybe they can figure it out that way through calculus or something like that. My question was with the fence, is it going to be any higher than what's there now?
No.
Okay.
Same height,
Same height? Okay.
same height.
How high is the existing fence?
I believe it's a 5-foot fence.
All the questions I had at the moment. Thank you.
Are you proposing a 5-foot solid vinyl fence, or?
Yes.
So so whatever relief the board grants, we base it on the plans. And like I said, when we first started to discuss your petition, I'm fumbling around, I can't even find it now. There is not anything, here we go. There's not anything on the plot plan that relates to the retaining wall or the fence. So we're going to need you to put those on the plan, because the building commissioner needs to know what relief we've granted, and that's how we do it. It's like, okay, here's the plan, here's what was approved. And again, I have that concern about making sure that that the retaining wall is within your property. And the relief you're seeking for the fence is to put a 5-foot solid vinyl,
Yes.
presumably in the same location as the existing fences.
Yes.
Would you be able to have your surveyor mark that location on the plan?
Yes, I can come back to that.
Let me ask, is there anyone in the audience who cares to be heard in connection with this request for a special permit at 1 Carroll Road in connection with installation of a new pool and replacing an existing fence? Sure. You know what, can you hold on just a sec, though? Because this is being videotaped, we really need you to speak into the microphone so people can understand.
I'm at 17 Robinson Road. My side yard faces Jeff's yard, and my wife and I have no objections. It seems like they're just improving their property. And just one statement about the concrete fence. Being a son of a stonemason, it is starting to crumble, and we do have a lot of trucks that go by the property, so I can see over a period of time replacing that fence with a resin fence or a wooden fence would just be a safer situation.
Thank you. And could we just have your name for the record?
My name is Joseph H. DiCicco.
Thank you.
Thank you, Chairwoman. Thank you. Yes,
All right. Thank you very much. How does the board wish to proceed?
Just had another type of question here. Suppose Mr. Simpson was just rebuilding a portion of that fence, and it's been established that he has, it's been there. Would he even need a permit? Repair versus replacement?
I don't know, I'd
is
have
what-
to go back and look at the, I haven't looked at the code section since
Okay.
before this came in.
Almost like he's just repairing what's already there, to me, but
Yeah, I mean, there is that provision
there is one in,
that one of the city council members put in many, many years ago when he wanted to replace his fence. So, but we don't look at that too often. Yeah, I looked at that a month ago. Remember what section it is? Pardon?
Placement, though, than a repair.
Yeah.
Mr. Simpson replaced one area of the fence, maybe one from post to post, every year, then it would be different, right? I don't know what they
Fence goes all the way
consider.
to the back of the around the back of the property.
Yeah, I don't know.
Two sides that we'd be replacing.
I don't know what they consider repair.
Yeah, I mean, that might be something you want to, if you want to bring that up with the building commissioner.
Placement as opposed to just fixing
Yeah.
fixing it with mortar, so I would say this is a replacement.
All right, so how does the board wish to proceed?
Well, I'm fully prepared to vote in favor of it tonight, but if other members need to see where that foundation is for the fence and where that fence is going to be located, then the drawing would have to be updated.
I would also be ready to support it.
Yeah, I don't have any substantive concerns with it, other than we need to have the location of the fence marked on the plan. And like the issue I said, that I can't vote in favor of enclosing any of the city's property in case that retaining wall is not inside the property line.
West, are you saying that would require a continuance or a condition?
Well, I think the plan is incomplete, because it doesn't, so, and even with the relief that you sought was to install a fence higher than 3 feet, but we didn't know until you just said that you wanted a 5-foot vinyl fence. So that's also something that we need to, knowing that is helpful. But I think you need to mark the location of the fence on the plan, that you're seeking the relief for, because we always require everybody to mark the fence on the plan. So I think you'll need a continuance to get that done and then submit an updated plan. But let me ask, so does anybody else have any concerns or anything that they want to share? No. So if you can just update the plan. We are having our next hearing on July 17th. So I don't know if, sorry, what did I just say? Yeah, no, we're not having it on July 17th. But you know what? Oh, hold on. You know what? Because I'm looking at the calendar that says June 17th. So are you available on July 21st?
I am not available on July 21st.
Do you have a representative who's available on July 21st? So would you like,
No, I can be here on the 21st.
okay, so you want to continue this matter to give you time to get that information on the plan?
Yeah.
We've even extended things, and, I mean, you probably might want to get going on this anyways, but we could extend this to an August date too, if you wanted to, and,
No, because I want to get in the schedule so that
okay.
you're in line to get it done by next year.
Yep.
So I just know the plan is gonna add the fence
And the retaining wall?
and the retaining wall, okay. And then the height as well.
Well, I guess it's going to be up to you. It might be a good idea for you to talk with the building commissioner, because if you want to put the, fence right on the 2-foot retaining wall, then the relief that you're really seeking is to install a 7-foot fence
Okay.
on the lot line. But it probably makes sense for you to just touch base with him in terms of, whether, I think, so yeah, this is.
Madam
this
Chair,
is-
if he does do that, if he has that little step there, and he talks to the building inspector, then he might not even need to come here for a fence, is that correct? I mean, the fence is gonna be 5 feet, but if it's offset from the foundation, that's 3
It
feet?
still exceeds 3 feet.
What? The fence? Yeah. But he's, yeah. No, I guess you're right there, but he's, I mean, everything's the same
Yeah.
as before, but it's kinda hard to
Yeah.
wrap your head around.
Have you had any communications with the building department about the fence?
I've been to the building department about 15 times with various photos and dimensions and
Sure.
whatnot, but no, they
About
didn't
the fence
mention
or
that.
just the
That's all.
pool?
They didn't mention that. No, the fence was discussed, the retaining wall was discussed. We talked about the fact that they thought I was gonna have to take out the retaining wall, and no, I'm bringing the excavator in through the side in the garage and gonna lower it in, and I'm not gonna disturb the retaining wall. So we did
Oh,
talk
all right.
about the fence,
Yeah,
but
so I would
that
hate
wasn't
to
mentioned.
have you, do this plan and give it to us, and then we say, okay, and then the building department's like, yeah, no, that's not cool. You know what I'm saying?
It's gonna be an 8-foot, at least an 8-foot fence, because the one corner of the house, that's probably 3 foot, 5 foot. It's at least 8 foot. It's not a straight, the
Oh, because it
top
goes
of
up
the
at
fence
the
is
end?
level, but the road is sloped,
Yep, yep,
so.
okay. How does the board wish to,
So I'll make a motion to continue to the July hearing.
Second.
all in favor? All right. And we have another form for that we need you to sign. All right, so this matter is continued to the next meeting in July. Thank you. The next item on our agenda is the petition of Maria Lavalley and Cameron Daniel, 2 Eastern Ave, seeking a variance to install a fence higher than 3 feet within the 25-yard front setback.
I have no supplemental information for this one.
Excellent. Hi, good evening. I assume you are Maria Lavalley and, or, how do you pronounce that? Lavalley. Lavalley, okay. And Cameron Daniel?
Yes, I'm Cameron, yep.
Okay. All right, so we have your application, so if you want to explain anything about it, feel free.
Yeah, definitely. Good evening, Chair Pinkham and members of the board. So we're Maria and Cameron. We are requesting a variance from section 5.3.2 to install a 4.5-foot open-style scalloped white vinyl picket fence along our front property line. This is a modest request for an open decorative picket design that maintains full visibility and is consistent with the residential character of the neighborhood. Specifically, our hardship arises from directly from the unique physical conditions related to the shape of our lot. Specifically, the placement of our home close to the street and the driveway configuration, which together severely limits our usable outdoor space. Unlike many neighboring properties that have functional rear yards, our lot layout leaves the front yard as the main viable area for a meaningfully enclosed outdoor space. So thus, we cannot comply with the 25-foot setback requirement for a larger fence because we do not have a large rear yard area. Strict compliance to that rule would render a significant portion of our yard unusable. We also cannot comply with the 3-foot height limit due to significant safety concerns. Our property sits approximately 50 feet from Montvale Ave, a heavily trafficked main road, creating a genuine safety risk from vehicle traffic. Additionally, we are right across the street from Woburn High School, as well as a bus stop that goes to Boston, generating significant daily foot traffic. And a 3-foot fence would provide, no meaningful safety barrier for these conditions. We have obtained signatures from 5 of our closest abutters, all of whom have reviewed our proposal and have no objection to it. And just kind of as a summary, this proposed fence is an open picket design. It's not a solid privacy barrier. We want to preserve sightlines and neighborhood aesthetics. It terminates at the driveway and does not obstruct any intersection, fire hydrant, or public way. It's residential in appearance and consistent with other fencing visible throughout the neighborhood. We do note that there are 3 houses within the near block that have similar white vinyl fencing, and our direct neighbor has a solid 5-foot fence on the shared line as well. And we want to note that the hardship is tied specific to our parcel in our shape lot and does not reflect conditions generally shared across the zoning district. So granting this variance should not nullify or substantially derogate from the intent of the ordinance or create a substantial detriment to public good.
So your plan also does not include any information on the location of the proposed fence?
Yeah.
So we're going to need that from you too?
Yeah, that would be great if we could. Yep, yeah. That's the signatures of
Thank you.
the 5 closest abutters, so in front of us, left and right, as well as one behind. We didn't include it on there, but we do have the quote from Reliable Fencing, which outlines it in the front there. So it's in the bottom right-hand corner of Exhibit C. So it would be 48 feet with a gate and then another 8 feet across the front of the property, terminating in that driveway. And 14 feet up just to go to the house, the edge of the house on the property. There's also a quick rendering of how that would look as well for Exhibit B.
Do you want that one as well, Madam Chair?
You don't have that?
No, you should have all the exhibits already, yeah.
Oh.
Maybe.
It was just the signatures that we didn't have when we
Okay.
submitted. Yep.
Oh, okay.
Sorry.
Exhibit B?
Exhibit C is the location of the fence. Quote from Reliable that says the measurements of the fence, where it will be.
On the bottom right-hand corner of that, and then Exhibit B just shows a digital rendering of where it would be on the property line.
Yeah, so that's not going to be sufficient. So I don't really understand, what additional benefit do you get from a scalloped fence that, I strike that. My first question is, where's the 4.5-foot measurement on the
Top of the
scallop
scallop,
fence? So that the posts basically are 4.5
Yeah.
feet? Okay.
They go down to about 3 feet 8 in the middle, or maybe something
Okay.
like that, yeah.
How does that extra height give you how does that do anything more for,
Can't just step over it if it's 4.5 feet. I think a 3-foot fence you might be able to step over.
Yeah, it's significantly more security for pets, small family members, friends and family that are in the area, as well as a much higher deterrent for anyone coming into the yard. Like we said, high foot traffic. There are coyotes in the area, or able to jump significantly higher, so
Well,
a
couldn't
little
they
bit of
just-
extra height.
Couldn't they just walk down your driveway or up your front stairs? I mean, the fence isn't going to keep.
There would
This-
be a gate there, it's not in the rendering, but it is in the
Reliable quote.
reliable quote in Exhibit C, so it
Is
would be
this-
fully fenced.
Is the fence going to go back to your house?
Yes, that's
Yes,
a
it would
building.
go along the driveway to that corner of the house there. The driveway would be open. 14 feet back to the house there.
Okay. All right, any questions?
A couple. Excuse me. As you face the house, the property to the left,
Yes.
those bushes out, is that their fence?
Yes, that's their fence. It's a 5-foot fence. It fully encloses their house, and those trees are 20 feet tall, by my best guess.
How about across the street?
Yep. Across the street, that is a 5-foot fence across the street. I don't know if it's in a direct picture, but that is a fully private fence as well.
Or do you know if either of those neighbors got permits for those fences?
I don't believe the one to our left got a permit, but I believe it might have been historically placed in. She said she's lived there for, 50 years. I do not know about the house. We weren't able to talk to the neighbors across the street.
Or 87, so the aerial photo of 87 shows a dumpster full of stuff in the driveway.
Yep.
Was that house recently under construction?
We have just moved in as of March. We just closed on the house in December, so we're not aware, sorry.
Montville Ave.
So the one to our left and when you're facing is the corner of Montville Ave.
No, I mean, so across the street from you,
Yeah, so that's the one with the dumpster that we were just talking about. Those are the two corners. So if you look at
That's 87
the
Montville
assessor's
Ave.
map, 87 and 89. So they both have fences.
yeah, do you know how tall that fence is? It's a
Yeah, the one in the back that's on Eastern Ave is 5 feet, and it's a full privacy fence. The one in the front, I am not sure what they have in the front there. I believe it is higher than 3 feet, though. And though for 89, it is fully fenced on all sides and has the trees on all 4 sides as well.
How long have you been at your house for?
We just moved
We
in.
just moved in, so we closed in December and moved in March.
I was just more curious about your neighbor's 5-footer there, and it appears to be there, been there since at least 2012.
Yeah, I can't speak to that. I'm sorry.
Yeah, no, I was just,
In my short conversations with her, my guess is that it's grandfathered in some way. It seems like it's been there for a long time.
Is this proposed fence basically going to be the same that's in your back? It looks like you have back
Yes.
scallop
Yeah, there's something
ones.
that's already pre-built there. We just want to match that. Yep.
Let me ask, is there anyone in the audience who cares to be heard in connection with this request for a variance to install a fence higher than 3 feet in the front setback?
so you know that I really like seeing these type of petitions with picket fence and not these 6-foot blockade fences that are being put up everywhere,
Oh, and some of them illegal.
right? I wonder how
Most
that
of them illegal.
Tried to do it right. Get in front of you guys.
But no, I think it's, I think I would certainly support this request for a variance, but I would tie it in that it stay as a 4.5-foot white vinyl picket fence.
We're fine with
There was
that.
a decision that was made, but I think we're gonna have to continue this anyways, so we can see on the plot plan where exactly the fence is gonna be. And I think the board always likes, I don't know if you heard earlier, that, you know, we don't wanna have it in the city's property, or maybe having it an inch or 2 inside in your property and whatnot, but.
Well,
Say that again. Sorry.
I don't think there would be a risk of the fence being on the city's property. I think in our proposal, we set a foot back from the property line. Our property line is on the sidewalk.
Yeah, essentially as close to the sidewalk as possible. They need to move it back, obviously, to properly dig in the posts, right? But, as close to that sidewalk as possible.
Yeah, we just like like to see it on the drawing inside.
Yeah, I
the
completely
property.
understand. I don't think that we understood that requirement when getting the plot plan with.
Sure.
Yeah.
And just, I have to say that I've seen a lot of damaged plastic
Yeah.
picket fences that are on the side. I mean, I see them all the time. And I don't know whether it's, sidewalk plows or what, but, so, I don't know if that,
Yeah, I mean, we're responsible for our own sidewalk, so I mean, we would be the only ones plowing in that area, so we would make sure it's okay. But if it is a matter of materials, we're happy to adjust from vinyl to something else too.
I mean, it's whatever you want, just, it's like, and I see them broken and it doesn't seem like anyone repairs them. I don't know if it's a pain to get the parts or
Should
what.
be pretty easy. Yeah, they're modular, which is the nice part of it.
But, so do you want a continuance so that you can get
Yes, if that's a deciding factor, yeah, we would love to continue it then.
Okay.
Yeah.
So we have a form that we'll need you to sign to continue it. Are you available on the July 21st date?
Yes, I believe so. It'd be funny if we said we weren't, but
And then I ask if you have
We're
a
on vacation.
representative
No,
who'd
no.
be available. That's a Tuesday.
we're free. Yeah, we're free.
Is that no parking sign still there?
So there is a no parking during the morning because it's part of the bus route for the high school. Yes. Yep. So there's no. It's just the morning during the week that there's no parking on the street. I think it says it's 9 to 11.
Yeah.
We utilize the driveway, so it wouldn't block anything. Yeah.
The city might plow those sidewalks just because if it's the school.
They did not this
Definitely didn't this
winter.
year.
So,
That back.
yeah.
That would have been great.
Yeah, sorry.
Oh, sure. Sorry.
Yeah.
I'll make a motion to continue to the July hearing.
Second.
All in favor?
Aye.
Right. Yep. All right, so we'll see, and so it would be helpful if you can get that in early, so it could
Yes.
certainly
Yeah, I'll
not.
make sure that there's copies
Okay.
of it.
What
All right.
exactly do we need to put on the plot plan?
Yeah,
So
just
you
sort
need
of
to put the, well, so, it would be helpful to have you, just mark your surveyor's gonna know how to do it.
Sure.
But they put, it's lines with little X's
Yep.
that denote the exact location of the fence.
Okay.
And, any gates or whatever. so
Yeah,
that-
of course. Yep.
Okay.
Yeah, we'll have them talk to our fencing person and make sure it's on there.
Okay, all right.
Thank you so much.
Thank you.
Have a great night.
You too. The next item on the agenda this evening is the petition of James Gallagher, 11 Lillian Street, seeking a special permit for an addition to a single-family home. Welcome.
Hi, excuse me. My name is John Andrews. I'm a project manager with GA Design Group, helping represent the Gallaghers in this case.
Okay, welcome.
Welcome. Welcome to the rest of the board members as well. So what we have here is a single-family home, 1,500-plus square feet, four-bedroom home. What we're proposing is to have two additions to the home, one in the front, which will be the front where you're seeing the 9-foot-8 setback, and then also the 24/7 setback there. Then on the rear, so as you can kind of see, these two additions will sort of square off the house, make it look more like a colonial. In the rear, we have a small addition as well. And then why we're looking for relief on this, front setback, overall width of the property, and then of course the coverage, is we have a family of 6, and we're looking for more space mainly in the case of bedrooms and an expansion to a kitchen on the first level, and then also on the first level towards the front of the house, that addition will be a study. We just kind of ran out of space. So that's kind of what we're looking for there. Each of these additions are within the height, total height set by the bylaws. And there'll be a regular foundation, not attaching to the existing foundation, but not increasing the basement space there.
All right, and it's just going to be a crawl space instead of a full foundation?
Exactly, yeah.
What's in the existing basement?
What's in the existing basement?
Yeah.
It's a full basement, full basement height. It has the mechanicals down there, but it doesn't have any living space.
Where are there laundry facilities in the house now?
Yes, I'm James M. Gallagher, and there is laundry on the first floor next to the kitchen in the first floor bathroom that you see drawn there.
Okay, that big bathroom has the washer dryer in it.
That's correct. I would not call it big, but it does have a washer and dryer. Yeah.
Okay. All right, because I'm like, they're not here. Are they in the basement? Where are they going to be? And so are there 2 kitchens in the house now?
No, there's just one.
All right.
So there's an existing plan and the proposed on sheet A1. Everything that's in dark shows what the expansion
Sure.
is going to be.
The sheet A1 shows an existing kitchen at the back. I think it was just mislabeled. I think like the entry of the foyer was mislabeled as existing.
Oh, okay.
And then
And moving up to the second floor, you can see where the expansion of the bedrooms are.
yeah. Is there I thought I had a note on here about, is there any exterior access to the basement, like a bulkhead or anything?
So there is a door on the Albert Street driveway. And you can just walk right in. The house is kind of terraced into the corner of Lillian Street and Albert Street.
It's kind of like a walkout, but it's a shorter door.
So wait, is that the, hold on a sec, that can't be. Because it looks, you have like French doors. That's not the access to the,
Oh, I'm
So
sorry. they didn't
it's
show the
not, you
access
wouldn't
to
see it on the drawing, that's why.
it. It's not on the foundation plan.
all right, is it shown on any of the plans?
No, it's not shown on the foundation plan. You can put that as a condition, though, and I
So
can...
you have direct access to the basement?
Yes, we do. So it's, the new addition's not cutting the access off to the basement. It's kind of like on a corner lot.
All right, I don't have any concerns. I think it's, I can understand why you had to come to get the special permit, just to square it off, but it's kind of unfortunate that you had to do that for these, small but very strategic, additions. Anyone else on the board have questions?
It'll still be able to fit 2 cars on your Lillian Street driveway? Or is it gonna
Yeah,
take
that
a
won't
little
impact
ways?
it. You'll still be able to fit 2 cars there.
I guess my question was, just looking at this, you've got one access into the house from Lillian Street. And actually, now you have 2, right?
Yeah. There's the French doors, too.
Yeah, where the French doors are,
Yeah.
the other set of doors that will face, that's gonna be gone, and you're just gonna be using the main door on Lillian Street.
Right. Yeah, there'll be the main door in the front, and then there's also
There's still
the
a
French
French door,
doors where the...
Well, the side, though.
Right, from the side, right. And that's actually what's used quite a bit right now.
Right near the driveway.
That's all I had, thank you.
And the addition's just,
The addition, as you see on the plot plan, is just those
yeah.
2
All right,
sections.
and it's you're not adding another bedroom upstairs? It's
No.
it's like a storage,
expansion
like
of those
basically
bedrooms.
closets and rooms.
I think what happens here, too, is that we're removing some interior walls on the first floor. So that's what gets a little bit confusing.
It's currently a 4-bedroom, 2-bath, and you're keeping it a 4-bedroom, 2-bath plus an office. Right?
So we're using one of the bedrooms as an office right now.
I understand, so what, but you're,
But it's not changing the
yeah,
original configuration.
the tax record shows
From the
4-2.
deed, right,
Yeah.
from the tax record.
And you're gonna keep this as single-family, correct?
Yes.
And since there's no one else in the audience, I don't feel compelled to ask if anyone else wants to. How does the board wish to proceed?
Make a motion to approve the special permit based on the drawings and documents submitted this evening.
All in favor of the pending motion? All right, so that passed. A decision needs to be prepared and filed in the city clerk's office. That typically takes a week. There's a 20-day appeal period, so no building permit will issue until that appeal period expires.
Does the appeal period start after today's meeting? or
No,
the-
it only starts when it's filed with the...
Oh, when it's filed, okay.
Yep, okay.
Thank you.
All right, good luck.
Thank you.
You're welcome. All right, the next item on our agenda is approval of the meeting minutes from our May meeting. I did not have any corrections or edits. I don't know if anybody else has any that they want to share.
Make a motion to approve the minutes as written by I was just gonna say the chair, but by our clerk.
Second.
All in favor?
Aye.
All right, that passed. I'm not aware of any other matter that's legally before the board, and so I would ask for a motion to adjourn until our July meeting.
So moved.
Second.
All in favor? Okay, we are adjourned. I'm glad we could find a random day in July that worked for everybody.